due to me experiencing headaches. I'm experiencing neck pains from being hit in the head. You know, I had a hard hat on. I got lucky.
You did get lucky, Rich. I've handled a lot of cases like that, and you know, the hard hat saved you. It doesn't always save people, but it sounds like it saved you.
Right.
Look, let me ask you, if you're still on the line, does the crane operator, does he work for the same company that you do? And please don't name the company. But,
no, I'm not gonna. No, he works for the same. He works for the same company.
Okay, so here's sort of how it breaks down, Richard. And so it sounds like you're probably covered by what's called the Longshore and Harbor Workers Compensation Act, which means you're a longshoreman. It's a scheme, a payment scheme, basically like workers' compensation, so that it's a no-fault scheme. If you're hurt on the job, you're entitled to a certain percentage of your wage. If you have a permanent disability, you're entitled to a lump sum payment. You're entitled to have your medical expenses paid. I presume you made a report. It sounds like it was potentially a very serious injury.
Right.
So the short answer is you probably don't have a claim against the crane operator if he also worked for your employer. You may, however, in situations like this, maybe not in yours in particular, but the general viewing audience needs to know this. In this kind of situation, you may have other claims. For instance, if there's a malfunction of the crane, you may have a products liability claim. And so those and sometimes a subcontractor, if a subcontractor or someone who worked for another company was operating a crane, you may have a claim as well. Those are things that, if the injury is severe enough, we look at very, very closely to see if there's potential of recovery for someone who experiences a serious injury. Sounds like, Rich, maybe, you know, again, I know it's scary and was bad,
yeah.
But it sounds like, you know, you got really lucky. I would make sure your medical expenses are paid. I would make sure and document the injury if you hadn't already. I would get a thorough physical from a doctor and see where you stand. And if you have any questions after that, you can call our office or call other attorneys who handle these kinds of cases.
Let me ask you this, Jim, and he mentioned that was July, so I'm assuming July of last year. Mm-hmm. Time-wise, does he need to...
Don't wait around, no.
Okay.
So July, it's coming up on a year. You don't need to wait around if you intend to pursue something. And again, attorneys who handle these kinds of cases will talk to you about it for free, confidentially. Your employer won't know that you've talked to an attorney. Sit down and ask them all these questions.
Right.
Bring the details of your case. And if you decide you don't want to go forward, you don't have to, but at least you know at that point what your rights are.
And Jim, and you mentioned this a couple months back, and I remember he really should, I think based on what you said, Pat, he should keep those doctor's exams going, shouldn't he?
Well, at least get an initial thorough one. And if the doctor shows you checked out and you're okay, that's good. But you need to, a lot of people, you know, shake it off and go back to work only to find out 6 months or 8 months later their back is hurting them, their neck is hurting them. They go to have an examination and they have a significant injury, maybe a disc injury that requires a surgery. Well, at that point, if you haven't been to the doctor for 6 months, it becomes very difficult to prove whether your injury was caused by the accident at work or by something that's happened since then or before then.
Right.
And so it's very important if you're hurt seriously or think you may be, to go to a doctor. One, because you need the care to get proper treatment, but two, to document what has happened.
Okay.